Hello, welcome to Who's Home Podcast with me, Suzanne Rocha. And today our topic is called Legacy at Risk, the truth behind planning and probate. And I'm so excited because I have Aaron Feldman, my guest today, with Feldman Law Group in Walnut Creek. So welcome.
And thank you for having me.
Good. I'm so excited to have you here with me, Aaron, because you are the rock star in estate planning and probate. I have to just put that out there because we've worked together. I've just really enjoyed your expertise, and I'm so excited for us to share today some hot topics when it comes to planning and probate.
And as an attorney who deals with probates and trust administrations, I can tell you it is really great to work with professionals like you when we have real estate to deal with.
Oh, that's great. And I didn't pay him to say that, that's for sure. But let's kind of get into the meat of it. So really, we're talking about legacy. And with legacy, it can be lost, it could be preserved, or it could be lost. And what I mean by that is that the planning stage of estate planning, we really are preserving the legacy of an estate, of individuals or families. And so let's dive into that a little bit. And if you can kind of explain what is the difference between a will and a trust?
Well, thank you, Suzanne. That's a very important distinction because a will is a simple document that will transfer wealth to your heirs upon your death. But it is not a very easy document to include different scenarios, and it also requires going to court for probate. So a revocable living trust, which is the main type of trust that we have for families, is a very flexible document. You can build contingencies and scenarios into it more easily. You can have funds held in trust if there are beneficiaries that are minors or who have special needs or other scenarios where you want to protect them, addiction issues, for example. So it's a way to control your gifts in certain situations, and it's much more robust to allow you to do that.
Exactly. And back, and I know you and I have joked about this, back in the day, many people thought, especially boarding a plane, I'm going to go write my will on the cocktail napkin in the bar and see how that holds up.
And if you're really old enough, you remember they used to have mailboxes inside the terminals, and people would just throw it into the mailbox and send it to their family.
It's amazing. It's amazing.
But that was the way things were done. People didn't think they needed a trust because they feel like the Rockefellers have a trust. I'm not a Rockefeller,
and that is so true. People really thought, wow, my estate isn't big enough. I really don't. I just have a little house, or I don't have much. But that's really not the case.
No, and the reason a trust is so useful is because it's not just about transferring wealth upon your death, which is what a will will do, but it will protect you and your spouse or partner during your lifetimes, because what we know is that once you reach age 75, you are 50% likely to have some disabling event, whether it's temporary or permanent. And if your assets are in trust, then your trustees can manage those for you during a disability. And a will can't do any of that.
No, not at all. And I think even mentioning the age 75, a lot of people put off estate planning. They think that is for later in life. I'm not anywhere near that age. But I'm seeing, especially in real estate, I'm seeing so much, even people in their 40s, 50s, they don't have any trust. They just have, the joint tenancy.
Yes, and I have somebody coming to see me this week who is a financial advisor. And all he does is tell families that come to him that they need to have a trust. And he's in his 50s without one. So he's finally taking care of it himself.
Exactly. Because people think they're too young. And it can happen, and it should happen at any age to set up your estate.
Especially if you own real estate. And people think, well, I don't really own it because I have a large mortgage. But yes, you do own it.
You do. Yes, you're on the title.
And then the second thing is, if you have young children and own a home, you really need a trust, because if you don't have a trust, if something, God forbid, were to happen to the parents, if you go through probate, the money would be set aside in a bank account, and we know how interest rates are at the bank, and it's stuck there in a very cumbersome guardianship account. Whereas if you have a trust, the money is in the trust and the trustee can manage it. The investments can be a little more robust. The spending of the money for the benefit of the children is easier, not as court controlled. So there's lots of reasons to start your estate plan younger. And then the other benefit of having a trust is that it will be modified and updated as you go through life.
Exactly, because they think like, oh, I have to make these big decisions now. I can never change it. But in fact, people need to revise their trust. And I know you work with your clients of doing that every so often, correct?
Yeah, we have a system in place to reach out to our clients every 3 to 4 years.
Perfect.
And some clients, we do it even more frequently if they're older, but absolutely want them to come in every 3 years for a free consultation and review, because a trust, imagine if you bought a car and you never had it tuned up, or you never had the oil changed. Eventually it would break down, and an estate plan is the same way.
That's a great example, because it's true. It's something's going to happen, whether you want it or not.
Laws change. Start there. I mean, we've had a series of changes to laws affecting property taxes, estate tax thresholds, retirement accounts. So we want people to understand how these interplay and how they may affect what their goals are for their estate plan.
And speaking of special needs, let's back up a little bit and talk about how you and why you got into your line of your career.
So I did not start off as an estate planning probate trust attorney. I spent many years doing other types of law. I did litigation. I defended lawyers who were sued for malpractice for many years.
I bet that was fun.
They're terrific clients.
Yeah, aren't they? I bet. That's why we're laughing.
That's why doctors make the worst patients, lawyers make the worst clients. Absolutely. And eventually I reached a transition point about what I wanted to do with my career. And a couple of my law school classmates who married, their daughter is autistic and on the spectrum. And so they encouraged me to look at special needs planning as a area of practice. And so I decided I would shift my focus and become a specialist in that area. Started attending all of the key
fabulous,
seminars and conferences, and took off from there.
Wow. And that is, so many people don't, unless they're impacted by that, they don't know what to do, where to turn. And that is amazing expertise that you could offer.
Right. And so to back up just a little bit further, even when they were telling me about their daughter and how I should work in special needs, it turned out, we didn't call it special needs back in the 70s, but my uncle was disabled, and he was really at the forefront of the independent living movement, because he was fighting to avoid being institutionalized. And so he had an apartment in Los Angeles that he was able to live in. So I actually had touched special needs planning without knowing it, even when I was in high school and college.
Wow. So you really were, was integrated in your life a little bit.
Right. And so when this came up, it really kind of touched that nerve. And I said, yes, this is what I want to do. And there are a lot of issues surrounding the special needs community. It all involves protecting and preserving public benefits.
Exactly. And that is a huge topic in itself.
Yes. And so it requires a lot of expertise and training to know how to best preserve those benefits, and how to fund a special needs trust, and just making sure that they qualify for the right benefits. For example, I had a client whose child was receiving SSI, and they did not know that once they retired, their child was eligible for a better benefit through their Social Security.
Oh.
And it's if you're a disabled adult child, you qualify for SSDI, and it pays a lot higher than SSI, and it has no restrictions.
Oh, wonderful.
And their child had been they were retired for like 5 years without knowing about this, because Social Security Administration doesn't send you a letter.
They're not going to say, could we pay you more?
Exactly. And so they just didn't know about it. And they were so relieved and grateful for that
Oh, I bet.
little piece of advice.
Oh, I bet.
And that has nothing to do with the estate plan
Yes.
we're working on. It's just trying to get people to see the big picture. Because that's another myth about estate planning is we are not document preparers. That's not what we're about.
And a lot of people think that way, or they check out online. What is I just need documents to fill in. There's questions. I'm just going to fill in some of the answers. It's a lot more to that.
Right. And so an online platform or even a legal document preparer cannot answer a legal question for you, cannot give you legal advice. And one of the things, unfortunately, that I see in my practice from time to time is somebody comes in after their mom or dad has passed away and they have a document that was prepared without legal advice.
I know. I've seen those.
Right. And so things fall through the cracks.
And I do. And I think it's really knowledge is key in anything. So
Right.
the more knowledge, the more education and advice that you can be given, the better, the better.
We are in the information business.
Yes.
And that, like you said, information is power, and you can make better decisions if you have better information.
Exactly, exactly. And I think that is such a stumbling block for a lot of people because they don't go through the extra steps. They're intimidated by attorneys making the appointment.
Or they're just thinking, what's the lowest price I can pay for a piece of paper without understanding how everything interplays? Because an estate plan isn't just that revocable trust. It's the healthcare directives. It's the powers of attorney for financial affairs. Because, for example, your retirement account is not going to be part of your trust. It lives outside of it because if it were part of your trust, it would be taxed horribly. And so it has beneficiary designations, and you have to check those periodically, make sure they're correct. But
That is wonderful information because so many people don't know that.
right. So there's lots of different areas, and that's where a financial power of attorney. So if most of your liquid assets are retirement accounts, and you have a house that's in your trust, but if you got sick and you needed money from the retirement account, your trustee can't help you with that. It has to be somebody who has an agent under a power of attorney who can then go to the retirement account and make withdrawals if you needed the money to pay for things.
And a lot of people don't know that until it's too late, until they try.
And when that happens, we have to go into court and get a conservatorship. And we'll talk about probate later, but as bad as probate is, conservatorships are 100 times worse.
Oh my goodness. I know I've heard that. I've heard that. And that is such another, area of expertise alone.
Right. And in fact, for real estate, I can tell you a great little story is that.
No, we love stories when it comes to real estate.
So I'll give you a quick story about conservatorship. I had a client who came to me, actually a real estate agent contacted me because they had a transaction that was supposed to close escrow, and the title company put the brakes on it. The gentleman's wife had advanced dementia. They were selling a rental property to pay for caregivers to keep her in the home. And he had downloaded a power of attorney off the internet and had it signed and notarized 5 years ago. He tells the title company, oh, she had capacity back then. And because it's community property, the title company said, prove it. And the doctor who had been her doctor at that time had retired since then.
Oh, of course.
And so we had to go to conservatorship to complete the transaction.
I know, and why I'm saying this is that we have in real estate we have run into these situations because the advanced there's dementia and other cognitive deficiencies arise, and they want to use that old paperwork, and they oftentimes, and that's why it's so important in real estate to have the plan ahead of time and to be able to cross that bridge earlier.
Right. And in this case, if they had a power of attorney that was done by a law office, the title company would have said, well, the lawyer vetted this family. So that power of attorney is valid. But they didn't. And again, this is a family that has a house in Berkeley and rental properties, plural. So a gross estate of $5-6 million. Why are they downloading documents off the internet?
I know.
And he had no trust either. It was,
Oh my goodness. They want to save time, they want to save money, and they think that looking on the internet is going to solve their problems. But it's like going to WebMD, right? If you have a medical condition.
oh, then you have every medical condition.
You have them all, right?
Yeah, these symptoms could be everything.
Exactly.
But in his case, and when I met him, he was already 80 years old.
Oh my goodness.
It's not like he was,
Yeah.
young and had
Sure.
delayed his estate plan. He had really pushed it out. And there we were.
Oh my goodness. My goodness.
And in terms of overall cost, by the time we were done with the conservatorship and the accountings, I think the legal fees were close to $50,000.
But look, what if they would have did that planning ahead of time too?
Absolutely. No, all of that would have been unnecessary.
Exactly.
Yeah.
And I think that's what happens is that people find just the initial upfront fees to be, they freeze and they don't want to do it.
Right. And so an estate plan, which costs a few $1,000s versus probate. And we haven't talked too much about this, but in California, probate attorneys' fees are very generous because they're based on the gross value of your assets. And because if a home is average price in the Bay Area, $1 million roughly, that means the attorney is entitled to a $23,000 fee. The executor is entitled to a $23,000 fee. So you're taking $50,000 away from your heirs by
Right off the top.
Right off the top.
Right off the top. And the thing is that sometimes people in their estate planning also get kind of frozen because they don't know who to trust, or they don't have anybody, or they don't want to make that decision. And I know you and I have talked about that, where if I've had 3 kids, I don't know which one to put in charge. Are they going to fight? But, are they going to think I favored one? So how do you handle that?
That's a very tricky issue. And I try to remind people I didn't raise your children. I don't know your children. But I do prefer one trustee. I don't make all your children co-trustees, because that doesn't work either.
No, it's
in my
challenging.
experience. We have one captain for the ship. The important thing is to be a little transparent about it up front. So tell your children what you've done. Let them know, this child's going to be the trustee. And then when something does happen, when people come to me after mom and dad are passed away, I tell that trustee to be as transparent as possible. Communicate regularly.
Oh, and the
with your siblings.
communication is the key, because especially if you have all co-trustees, talk about miscommunication and trying to wait for other people to respond. It can be a nightmare.
We had a case once where the one co-trustee lived in mom's house and wasn't motivated to cooperate and sell it. And we actually had to go to court and have her removed as a trustee. We had to have a whole trial about it. And then this was back in the time of 2008 when the real estate market was folding. So when they did finally sell it, the house had lost $200,000 in value.
Oh my goodness. And we in real estate, we run into that a lot, and that's kind of where some of the difficulties arise, where there may have been one of the adult children was living with the parent, they passed away, and now they want the house. They don't want to move, they don't want to pay, and then that's where all the sparks start flying.
Unfortunately, we've had a few cases where we've had to actually file and evict someone one of the siblings.
Oh, I know. And that's where, like I say, planning is so, so key so that we can try in this family, we can really focus on helping the family, helping at, especially when they have real estate to sell, working on that end because it can be really messy when you start to get into all these potential issues of, and when someone passes, a lot of old family baggage emerges, a lot of issues come out of it. And sometimes I think we're also psychiatrists, aren't we?
Oh, absolutely. And because all of those grievances come right to the surface because they don't have mom or dad to sort of.
Yeah, not the buffers. The buffers are gone. The buffers are
Right.
gone. So let's kind of get into a little bit. And first of all, I wanted to ask if somebody doesn't have anybody, and I heard a fiduciary is also a good option.
Yes, California has professional fiduciaries who are licensed and bonded, and they are an option for families who don't have a child, or if they do have children, they're either on the East Coast or maybe they work overseas. And so having somebody local who can take care of things, again, when you have a trust, it covers you when you become sick or disabled, even temporarily. So that's a good option. Now, obviously,
Yes.
professional fiduciaries charge for their services, but again,
But it's peace of mind.
correct. That is exactly what they can do, and not every fiduciary is the right fit for every family. So there are, we always give people multiple options and recommend that they interview them and see who's the better
Sure.
fit for their situation.
Sure.
Some of it has to do more with financial management, and there's some fiduciaries that's their sweet spot. Other fiduciaries have a more of a hands-on family feel to it, and then that's what the family's looking for. They're the better fit.
Now, what about when someone has a pet that is near and dear to them and they're really worried? Because I find that a lot in where they have pets, they want to make sure that they're well cared for and not just taken to a shelter. So how do you plan for that?
Well, that's part of the conversation you're having, just as you plan for their children. They do make plans for pets. We actually can create a separate pet trust. And we've done that a few times, especially for horses,
Oh, exactly.
because horses have a much longer lifespan potentially than the cat or dog. But, we do make sure that we provide provisions in the trust for money to be set aside, identify who is going to be the person in caring for that pet and what funds are going to be available to make sure that they can.
No, exactly. And that's that whole peace of mind that it's just layer after layer when we talk about, the planning stages.
Right. There are other special situations that require special planning. I went years without ever running into anybody who owned guns. In the East Bay, it's not as common as other places. And then I had a conference with a presentation about gun safety and gun trusts
Interesting.
and trustee liability, because you can draft a trust that says leave this gun to my nephew. Well, do we know if the nephew has any history that precludes them from being a gun owner?
Exactly.
So there are lots of things that you need to talk to your
That
clients
can
about.
get really complex.
It does. And how do you transport guns? I had a probate where my client's brother owned a lot of guns. He had a gun safe, so he was doing things the right way, but we had to transport those to a gun dealer to try to figure out how to dispose of them.
Oh my gosh, you've seen it all, I'm sure.
And it just, like I said, you go years and years without ever seeing a gun, and then it seems like every case.
Then you have all these cases, right?
They
at
all have
once.
guns. They all, so. But fortunately, I seem to be out of my gun phase right now.
So if we were to move along here and talk about, all right, we don't have a trust. What happens next? We have someone that passes. So what takes place?
So that's where, first of all, if you have a will at least that document nominates a person to serve as your executor. And there's a little more order to the process, but you still have to go to court and file a petition for probate, have the will admitted and verified, and then proceed from there in the probate process. And that can be smoother than the other example, which is there's no document. There's no will, and
they don't really know what their plan was.
Right. So if you have 3 children, no will, who is the executor or administrator in that case for the estate? Are there fights between the siblings over who wants to be the administrator? Because you haven't put that in writing anywhere, it's up for grabs. And we've seen fights among siblings where that has happened.
I know, and relationships really get broken down.
Oh, absolutely. Yeah, there's a lot more opportunities for those fights and to develop when you have no will at all.
Oh, I could
But
see that.
again, if you have no will, you still have to file a petition to be appointed as the administrator, and sometimes there's a competing petition, and then the court has to decide who should be the administrator. And in some of those situations, the court will appoint a professional fiduciary, going back to that, to act as the special administrator, because the court doesn't want to deal with 2 fighting siblings. They just want the probate process to get going, and they want the estate to be administered in a timely manner. A lot of times, the reason you want to get that going is sometimes there's a reverse mortgage on the house, and you're under a clock, 6 months typically, to pay off that reverse mortgage, which requires selling the house. And you can't sell the house without an administrator or executor for the estate.
So with reverse mortgages, as a real estate broker, we run into this all the time where we get the call that says, oh my goodness, we got to get going on this.
And they haven't started the probate yet when they call you first.
Most of the time there's like, what do we do? So of course, we have to get the plan together, but first things first is that they have to become appointed.
And in the Bay Area, it takes about 8 to 10 weeks to be appointed an administrator.
And I'm so glad you brought that up, because the time frames, I think that can roll us into time frames right now, because a lot of people always have the notion that probate takes forever. So maybe you can give us a little rundown of some of the time frames, if you can.
Oh, I definitely can. It's not forever, but it is a long process. The fastest you can do a probate is about a year, because there are 3 phases to a probate. I like to think of it as a 3-act play.
Oh, good.
And the first act is being appointed. And like I said, that's about a 10, maybe 12-week period. So there's 3 months right away. Once you're appointed as the administrator, you can then do all of the things that administrators need to do, which is marshal the assets and pay debts. So once an administrator is appointed, there is a mandatory 4-month creditor's claim period. And in a smooth running, simple probate, maybe we can complete the sale of a house in that 4-month window. Sometimes it takes a little bit longer, but we cannot file a petition for final distribution until that 4-month period is ended. So now we're 7 months in. Contra Costa County, if you file a petition for final distribution, your hearing date is 4.5 to 5 months out.
That's like buckle up. It's time is going to be ticking by, because you do have to go through the process.
Right. There are no shortcuts.
No shortcuts. You just have to go through it.
And so that can be delayed further if there's issues selling the house. We talked earlier about, do we have to evict a family member in order to start the sale of the house?
Sure,
Now you're delaying things 4 months, 6 months.
Yeah, and then we get disagreements among family members. All of that can transpire, and that's where it could be really complex and complicated. That's why it's so important to work with experts.
And one of the things that we've seen in the last couple of years is there are houses that are fully paid for and mom or dad dies, and they don't initiate a probate for years. For some reason, they just don't feel like starting that process. And then something triggers it where somebody needs the money out of the estate.
Exactly.
But what they don't realize is that there are property taxes that will be owed, supplemental taxes. There's a reassessment that occurs based on date of death value. And so even after we sell the house, we really have to hold off filing a petition for final distribution even further because we're waiting to find out what those supplemental taxes are.
And for a lot of people, this could be like surprise information because they don't know enough. And like we talked about, knowledge is key.
In the probate world, everything is surprise information.
It's all surprises. It's like, oh, I didn't know this. I didn't know that.
And the other thing that happens is capital gains tax potentially if they've waited 5 or 10 years to start a probate. Because
very interesting.
In an inheritance, whether it's a probate or a trust, there is what's called a step up in basis for date of death value of a house, of stocks. So you can sell them at that date of death value with no tax liability. But in real estate, if you wait 5 years, the real estate market has gone up. Now your house is $200,000 more of appreciation, but that's taxable. That's capital gain.
It's all the capital gains.
And the estate has to deal with that.
Sure. And I know a lot of people worry about inheritance taxes. Can you touch upon that just a little bit? Although we're not tax accountants.
No, but I can tell you that almost nobody has any estate tax liability to worry about. We are at $28 million for the estate tax threshold.
How much is that?
$28 million. So no, there's no estate tax. And the estate tax is owed by the estate, by the way.
Correct.
There is no tax on receiving a gift, whether that gift is during your parents' lifetime or during your inheritance.
Aaron, a lot of people just are so afraid, and I get that question a lot. Oh my goodness, what is going to be my tax liabilities?
And I think that's exactly why you see these delayed probates, because they think there's going to be an inheritance tax that they're going to pay when they receive the money. And in fact, it's creating opposite problems. It's creating capital gains tax for the estate. It's creating property taxes. So it's the opposite of what people think.
Exactly. And I've been contacted by a lot of people, or they said, oh, my parent passed away, and, they're trying to now think about selling the real estate. And I asked, well, when was that? Oh, it was about 7 years ago. And it's like, oh, okay. We've got some work to do here.
And, sometimes when you delay that, usually there is no will, but we have submitted some very old wills that we've managed to dig out,
That's interesting. Because most of the time, and when I talk about that length of time of not doing anything, it's really because somebody's living in the property, using the property, and they just don't want to make that move.
And the other area where estate plan documents are hard to locate, and I know you have a lot of experience with this, it's hoarder houses.
Yes, and they've been searching forever, going through box after box after box.
If you're lucky, the house is in a condition where you'll want to go through boxes. I mean, I had one recently last year where I met the client who was from out of state, and it wasn't a mom or dad, but it was former partner passed away. And I got 2 feet into the house, looked at everything, and walked out. It was really, really
they can
horrible.
They can get pretty
and
ugly.
Unsanitary, very unsanitary.
Yes.
And yet the realtor on that particular case brought in a crew. They were cleaning it out. And they found the original will.
Yes. That's what the organizers are for. They get their masks on, they get gloves, they get a team of people in there, and they can find a lot of good financial documents.
They did. And that was really helpful because without the will, my client would receive nothing from the estate.
Oh, my goodness.
And it would have gone to the decedent's mother and brother back in Minnesota And we know that the decedent had no relationship with them and did not want them to inherit. Because once we found the will, it was spelled out.
Spelled out, exactly. And that's another, of course, reason is because you want your legacy, your estate to be distributed to the people you want it to go to. And if you don't have that down, then it may go to somebody you may not want
Right.
to.
And the other piece to that, just really to get into the whole legacy issue, why a revocable trust is so useful is, say you have a child you want to leave a part of your estate to, you have 3 children, but you don't like the spouse of your child. And now you're worried about, how do I protect that? Well, if you have a will, they just inherit it. It just goes to them, and anything can happen from that. But if you have a trust and you're concerned about your child having either a bad spouse or other situations, you can say, well, I want their share to be held in trust. They'll get all the income from it for life. They can withdraw principal at certain ages or certain conditions, but you can control your legacy and protect your children by having good planning.
And that's really the name of the game, is good planning, because everything else it's risky. It's filled with a lot of fighting, a lot of disappointments, and a lot of stress. A lot of stress. And who wants that? You don't have time to grieve. You now have to hit the ground running and figure out what to do, like find documents. You're worried about their, estate, their personal items. But it really, I've seen it so much, Aaron, that it tends to be so overwhelming. And that's why I use that word, they get frozen, because they just don't know who to turn to, who to trust.
And when you go through the estate planning process, we help them to organize the other areas that you may not think about. People have safe deposit boxes, and there may not be anything valuable in them, but if you don't have the right documents, and you don't have it named correctly, banks will require you to file a probate just to look inside the
Just
safe.
to look inside.
Yeah.
I mean, who knows what could be in there?
Usually it's nothing.
Or it could be some big diamond
It can
or
be,
something
but
of value.
in my experience, people got a safe deposit box decades ago.
Or just came with an account, right?
Right. And they just put a social security card, a birth certificate, but nothing of actual value. And then they just kept it, and you don't know what's in it. So you have to try to get into it. And we've had to file probates just for that. Crazy.
Gotcha. Now, when it comes, I know in real estate, when it touch upon just a little topic of really what is a notice of proposed action? Because a lot of times in real estate and having to do with, estates, what in probate, can you just explain what that term is?
Sure. So when you are selling real estate as part of a probate, you are required to give notice to beneficiaries, creditors, and other people, and you have to do it within a certain time before the transaction closes escrow. You have to put the terms of the transaction, or the minimum. We're going to sell a house for at least $800,000 or whatever the numbers are. If there's been so going back to the probate process a little bit, there is a probate referee who does a formal appraisal of the assets, including the real estate. We're not allowed to just bring in our own appraisers to do that. And so, again, a notice of proposed action, it tells them there was an inventory and appraisal done, the appraised value was X, the sales price is going to be Y, and it just lets them know that the transaction is being conducted properly.
Fairly.
Right. And the title company needs to see that before you can close escrow.
Exactly.
And so there are situations where the attorney is not experienced in probate, and they haven't followed all of those steps. They haven't been quick to get that inventory done, or they've not used the referee. I actually had a client come to me recently where the attorney just filled it out himself, and it's totally invalid.
Oh, goodness.
Yeah.
Oh, goodness. And so it's all about, organization, knowing all the steps, guiding.
There are a lot of steps in probate. You have to notify the Department of Healthcare Services. Was there a Medi-Cal lien that has to be paid? You have to notify Franchise Tax Board. Are there state tax liabilities owed? Because, in many probates, we find that somebody who hasn't taken the time to prepare a will, as they get older, they're not maintaining their house, and they're not filing tax returns either. So there's all these deferred maintenance in all aspects of their life. And as part of the probate process, that's another reason for the time to close probate extends sometimes 2 years, because we're waiting to get tax clearances.
Wow. That
Yes.
is a lot to take in.
Yes.
It's a lot to take in. And can you imagine, like I said, can you imagine if you've had the passing of a loved one, you haven't really had the time to grieve, and now you're faced with all of this. And that's why utilizing such an experience like yourself, Aaron, an experience, an attorney to help guide them that knows all the intricacies, saves time, and really it can save anxiety, because it's a lot of anxiety.
It is. And the other part about the probate process in particular is it's a team approach. So when you hire my firm, you're getting a team of other professionals involved. It includes your firm as a realtor for the transactions. Because when we work with realtors we know and trust, who have the experience, they know what I need.
Correct.
I'm not getting a call from a realtor saying, hey, we're closing escrow in 2 days. And I said, I didn't even know there was an offer accepted. So there you go back to,
I know.
now we have to do a notice of proposed action.
Yes.
We can't close escrow for 15 to 20
15
days.
more days, yes. And so that's why working together as a team in a probate matter is so, so critical, because that communication has to take place. As a real estate broker and someone who has an amazing team, we really, just like your office, we work as a team so that we can communicate and make the process seamless for our clients, because we want them to not have extra anxiety, take a lot of the fear away. And knowledge, again, is key, but so is experience and working with someone who's really going to guide you effectively.
Right. And we had a disaster probate sale last year. I know for a fact it was the realtor's first
Not me.
transaction. No, it was her first transaction.
Oh, my goodness, yes.
Let alone first probate.
Oh.
And nothing went well.
Yes, you really got to know what you're doing.
I encourage my clients to work with the people we work with, such as your firm, so that they will have a really good experience. Because they're, like you said, they're already under enough stress. They're worried about moving out heirlooms and family photos, and they just need to know they're working with people who can take care of them.
Exactly. And we have really offer a lot of an estate and concierge program to help guide them and also give them the resources, such as the organizers, such as the people to go and clear out the house or do all the donations. It's all those little things that matter in the big picture, right? So that they can focus on, again, grieving, processing the death, so that we know that we're really effectively guiding, helping them. And I think that is really critical in a transaction.
Absolutely. I have a probate that's about to close right now. And my client, the administrator of the estate, is really angry. Why is he angry? Well, he's saying, I made all of these trips to the Bay Area, from Tahoe, to fix up the house and do this and do that. And I keep saying, well, what did your realtor do?
Correct.
Why didn't you use the realtors we were trying to tell
Correct.
you to use? And he wants the estate to pay him like $6,000 for gas, in addition to his executor's fee. And when I told him that's not going to happen, he just is very frustrated.
Yeah, they get very frustrated.
But he didn't communicate with us that he was doing all of this on his own. And the realtor didn't communicate with us. So that's an example
No,
of
it
where
just breaks
things,
down. It just breaks down, and there's a lot of extra work, a lot of extra stress. You would not have had to make all those trips, and it would have been done swiftly and correctly.
I'm sure you would have gotten a better price, but that's another
Exactly.
story.
And before we end our podcast today, there's a law that came out this year. Can you tell us a little bit about that?
Thank you for reminding me. So, as of April 1st, there is a new way to avoid probate if your house is worth less than $750,000 gross value, not net, and your other assets are below $186,000. And that's other assets subject to probate. Now, in the Bay Area, there aren't a lot of homes and probates that will fall into that category, but it is another way to avoid an extended probate because it will still require some court approval. So you'll have to file a petition with the court to have the assets distributed through that new law. And like I said, I have yet to come across a
But
situation.
I mean, there are some properties out there, states that may fall under that monetary guideline, but it can save some time, I hear.
Right, because that way it will be a 4-month petition process to the court instead of a 14, 18-month probate process. And again, you have to meet those specific criteria, and you're still better off if you get a trust. That's the
Exactly. I
bottom
mean,
line.
that's the bottom line, really, is that, and that's why we talk about legacy. We talk about, the truth behind estates and probate, because at the end of the day, it's the planning in your legacy is so essential, and nobody knows it, and you don't want, your family to go through this. And that's why you're planning, you're putting your trust in someone such as yourself to create an estate plan is going to make everybody's life so much easier.
Yes, and the main thing we do is we just make them aware of different possibilities because they haven't thought about what they can do with the trust or what they can't do. And so we're giving them options that they have maybe never even thought of, but it allows them to create a much more robust plan that they are so happy with at the end of the day.
So if somebody is listening, needs an estate planning expert, what are the steps and what should they do to get a hold of you?
So feldmanlawgroup.com is where we are, and you can contact us through our website. You can also call us, 925-283-6691, and we schedule consultations for you. You meet with me. We work out what kind of plan is best for your family, and we go from there.
Oh, that's great. And I could say that so many of my clients have utilized Feldman Law Group and have really, really captured the peace of mind that they are looking for in their estate planning. Thank you so much, Aaron, and thank you so much for tuning in with me, Suzanne Rocha at Who's Home. I'm Aaron Feldman, Feldman Law Group. We've discussed the legacy at stake, the truth behind planning, and probate. You know where to find me. Subscribe, tune in. My contact information is listed. Thank you so much for tuning in.